I just want to introduce our first panel and our chair of our first panel, Charles Ticker, mediator and estate litigator, and now author of Bobby Gets Bupkis, which I am looking forward to reading, and I'm sure it's a wonderful read. Over to you, Chuck.
Good morning, everyone, and it's working now, and thank you for all coming out of this bright and early. So this panel is going to talk about trust litigation, and each speaker is going to speak for about 10 minutes, and then we'll have some time for questions. If there's any questions from the audience, I think there are going to be microphones available, or you could just hand them up to me, and we also have some questions that we've prepared to discuss. So I'd like to take this opportunity to introduce the members of the panel. To my far left, we have Deb Stephens, and Deb was called to the bar in 1982, and
Thanks, John.
I missed the joke, but anyway, she began her career at Mills & Mills, and she was involved initially in civil litigation, and then over the years, of course, she concentrated in estates and trusts and capacity and family law litigation. She went on to join Schnurr-Kirsch Stephens, and in 2008, she was appointed the Children's Lawyer of Ontario, and that's a branch of the Ministry of the Attorney General, which is responsible for providing legal services and clinical services for children, all aspects of state tort and family law proceedings. And she went back to private practice and with the firm Goddard, Gamage and Stephens. In April 2017, she went on to join Well Partners as counsel and mentor. And just recently, last month, Deb has now joined the firm of Tupman and Bloom to act as their counsel and mentor. And she's also been an adjunct professor at the University of Toronto Law School, and Deb really doesn't need any introduction. I'm sure to most of you here, she's spoken at so many conferences. To Deb's right is Aaron Blumenfeld. Aaron is a partner with Bordner, Landner, Gervais, and he was called to the Bar of Ontario in 1995, and he received his LLB from the University of Toronto in 1993, where he ranked first in his class in his third year, and also a graduate of Princeton University, where he got his BA degree from the Woodrow Wilson School of Public and International Affairs. He has a varied practice. He advises clients in multifaceted international insolvency and fraud matters. He's represented shareholders in disputes over ownership of corporations and in cases of corporate wrongdoing, including impression remedies. He's advised investment advisors and investment securities companies in claims for negligent investment advice. He's advised and acted for clients on suits claiming breach of lending commitments, and also advised clients with competition antitrust issues. And he's also acted for beneficiaries of the large estate in proceedings to remove an executor for malfeasance and to recover money. And to my immediate left is Nimali Gamage, who is a partner at the law firm of Goddard Gamage in Toronto. And she has been recognized as one of the best lawyers in Canada in the area of trust and estates for the years 2014 through 2019. Nimali was called to the bar in 2001 and worked as a lawyer for the Walkerton Inquiry with then Associate Chief Justice Dennis O'Connor. In 2014, Nimali was the recipient of the Hofstein Prize, an award from the Ontario Bar Association that recognizes excellence in the field of trusts and estates law. Nimali's practice is comprised of both litigation and solicitor's work, and she has a special interest and focus on guardianship, power of attorney issues, elder law, estate planning, state litigation, capacity, and Ontario Disability Support Program issues. And she's also on the committee the Estates Subcommittee of the Civil Rules Committee for Ontario, a committee whose mandate is to make recommendations to the Attorney General for rules in relation to civil practice and procedure for the Court of Appeal, the Superior Court of Justice, and the Small Claims Court. And she's also frequently asked to present at programs by the Ontario Bar Association, the Law Society of Ontario, and other organizations. So it gives me great pleasure to introduce this panel, and our first speaker this morning will be Nimali, who will be talking about how you go about busting a trust.
Thank you, Charles, for those very fulsome introductions. I thought we were supposed to leave something to the imagination, but now you have it, our full histories and perhaps ages as well. So it's a pleasure to be here today. Thank you to Charles for having me on this panel. I'm going to start off with some basics before I get into talking about the actual busting of the trust and the litigation issues. Just want to start off with some basic trust issues. So the starting point for all challenges to trust is to examine whether the three certainties exist. And very briefly, for those of you who don't know what the three certainties are, they're number one, certainty of intention. So the language in the deed of trust must clearly show that the settlor intended the property in question to be held in trust. Number two, certainty of subject matter. The settlor has described the trust property in the deed of trust sufficiently so that it can be definitively ascertained. And number three, certainty of objects. There must not be any uncertainty about whether someone is a beneficiary of the trust. And before delving into discussing the three certainties, it's important to note that in the 2017 case of Angus versus the municipality of Port Hope, the Ontario Court of Appeal held that the three certainties are reflexive, meaning that although we consider the certainties one at a time, the consideration of the certainty of subject matter and certainty of objects may inform, or in other words, reflect back on, the matter of certainty of intention. So this is important as we go through the litigation issues to come back and think about. So first of all, certainty of intention. What are we really talking about when we say this? Did the settlor intend that the property be held by one person for another person's benefit? This kind of intention that we're looking for can be express or implied. It doesn't have to be formally documented or, in fact, specific language be employed. It can be oral or in writing. And the intention can be established even if the word trust is not actually employed. In the absence of a formal trust document, the court must examine the surrounding circumstances and the evidence as to what the parties intended, as to what was actually agreed, and as to how the parties conducted themselves to determine if there was certainty of intention. So how do we deal with this issue in litigation? What's the court going to look at? Well, let's look at what are the inferences that a reasonable person would draw as to the intentions of the parties from the parties' words, conduct, and the surrounding circumstances. The court will not consider possible intentions that were not clearly established. So, for example, in the 1993 case of Byers versus Foley, the court held that the two men who had purchased Seasons Blue Jays tickets on behalf of their rec baseball team were holding the Seasons tickets in trust because there were many indicia that the two men did not own the tickets exclusively. So what kinds of indicia are we talking about? In that case, two other group members discontinued their participation, and their shares in the tickets were reallocated to the group as a whole. Also, each member of the group would provide a pro rata share of the ticket price to the two men annually, and the group as a whole made a decision to permit a new member to join. Although the trust does not have to be written or reduced to specific wording, certainty of intention cannot derive solely from a moral obligation as to what should be done with the property. There has to be sufficient indicia from the words, conduct, and context to establish intention. So the second certainty, certainty of subject matter. Even if you can establish that the settlor clearly intended to establish a trust, the property that is to be held in the trust must be clearly identified. And if there's more than one beneficiary, their respective shares of the trust property must also be clearly identified. The property has to be ascertained or ascertainable from the terms of the trust or otherwise. So, how do we deal with this issue in litigation? You may be able to challenge a trust if the trustee has commingled the trust property with other property, such that the certainty of subject matter of the trust has been destroyed. Now, some case law suggests that any commingling of trust property with other property will destroy certainty of subject matter. But this year, the Court of Appeal clarified that commingling of trust property alone will not destroy certainty of subject matter under the general principles of trust law. This was the case of the Guarantee Company of North America versus Royal Bank of Canada, in which A paving business had declared bankruptcy, and the receiver in bankruptcy has established a paving projects account and a general post-receivership account. The receiver then commingled trust funds received for various paving projects in the same account as funds paid for debts owing. The Ontario Court of Appeal held that such commingling did not destroy the certainty of subject matter of the trust because the funds attributable for each purpose were identifiable due to the receiver's careful accounting. The funds were commingled only to the extent that they had all been paid into the same account, but they had not been converted to other uses, and they did not cease to be traceable to the specific project for which they'd been paid. And third, certainty of objects. So there has to be certainty about who the potential beneficiaries of the trust are. How do we deal with this issue in litigation? Possible challenges are such as trusts that are for abstract purposes that confer no ascertainable benefit on identifiable individuals. Also consider whether there's any gift made to an unascertainable class, or whether the class is too vaguely described, too broad, too subjective, or conceptually uncertain. So that's the Coles notes on the three certainties. So what are the different kinds of litigation issues that can arise, and how do we go about busting the trust? I'm not going to talk about all of them. They're dealt with in the paper written by me and my associate, Jessie Lamont. But in general, there's litigation issues around the settlor having requisite knowledge and capacity, the settlor of the trust being unduly influenced, the rules in Saunders and Vautier or Barford versus Street applying, was the trustee negligent, and should the trustee be removed? So in my remaining couple minutes, or maybe minute, I'm just going to... 3 minutes. Oh, my, 3 minutes. Hallelujah. Okay. So I'm just going to talk about two of those litigation issues. So first of all, that are mostly relevant to our fact scenario. First of all, did the settlor have the requisite knowledge and capacity? What does this mean? Did the settlor have an understanding of the nature and effect of the transaction? So understanding doesn't have to be perfect, but they do have to have a general understanding of the nature and effect of the trust. Now, the courts have held, importantly, that the relevant time to establish capacity is at the time the settlor gives instructions to prepare the trust, and that later incapacity will not invalidate the trust. So you have to consider the circumstances at the time of the creation of the trust. Did the settlor of the trust have diminished capacity? Did the settlor understand the effect of the document that he or she signed? Did anyone properly explain the effects of the document? Did the settlor receive independent legal advice? So in our fact scenario, does Brad do any of the talking or instructing or asking questions at the meeting with the lawyer, or is it just his parents? Was he given a copy of the deed of trust to review and ask questions about before signing? Brad may have been mentally capable of understanding the trust agreement, but did he have actual knowledge of it? Was there any opportunity for the lawyer to assess whether Brad was capable of understanding the trust arrangement? And the second really interesting issue for our fact scenario is the issue of whether the settlor of the trust was unduly influenced. And this is often where the really interesting and difficult litigation happens. As many of you in the room will know, undue influence is a situation where one person dominates the will of another, whether through manipulation, coercion, or outright but subtle abuse of power. In the trust context, as in the context of gift-giving generally, there are certain relationships that are considered to be relationships of influence: parent and child, lawyer and client, trustee-beneficiary, doctor and patient. But the existence of such a relationship between the settlor and of the trust and the trustee or the beneficiaries doesn't alone mean that undue influence exists. Rather, the existence of such a relationship can result in there being a presumption of undue influence that must be rebutted by the alleged undue influencer. And of course, these cases are so difficult to litigate because true undue influencers rarely leave a trail of unduly influencing behind them for us litigators to find. One must look at the circumstances surrounding the establishment of the trust to determine if undue influence existed. And just a great example of how difficult this is to litigate and to prove is the 1991 case of Goodman Estate versus Geffen, which went to the Supreme Court of Canada. The lower court found there'd been no undue influence exerted by two brothers against the sister who'd established the trust that benefited the brothers' children. even though the brothers were present at the initial meeting with the lawyer, because the sister ultimately didn't give any instructions to the lawyer at that initial meeting. She went home and thought about it, and then she later met with the lawyer alone to give instructions about setting up the trust. The Alberta Court of Appeal then reversed the decision, finding that the brothers had not rebutted the presumption of undue influence. And then the Supreme Court reversed the appeal court's decision, relying on the findings of the trial court judge that the presumption of undue influence had in fact been rebutted. So in our fact scenario, did Brad ever have an opportunity to meet with the lawyer or accountant alone? Again, did he do any of the talking and asking questions of the advisors, or was this all done by his parents? Was it tantamount to coercion for the parents to use the disabled sister and Brad's role as the only person who could take care of her after they're gone as a way to get Brad to set up the trust? And if not coercion, it was certainly manipulative. Would this be enough to invalidate the trust on the grounds of undue influence? I don't know, but we'll see as this day unfolds.
Thank you very much, Nimali. You know, when you were talking about that Blue Jay case, I think the citation was 92 or 93 when the Jays, of course, were in their prime winning the World Series. I query whether or not there'd be any litigation over Blue Jay tickets today. But thanks again. Aaron is our next speaker, and as you may be aware, in the context of the state's litigation, and particularly in will challenges, it's very common to see an estate trustee during litigation appointed. So Aaron's been asked to talk about the question, is a similar remedy for a trustee during litigation available in trust litigation?
All right, thanks, Chuck, and thank you, Charles Wagner and his firm for setting up this valuable morning, and thanks to all of you for coming here so impressively early in the morning. I haven't yet had my shot of coffee, so I may be a little less articulate than I'd like to be, but we'll do my best to answer the question. The short answer to the question, I think, is yes, but there's surprisingly little authority on point, and that either I or the summer student Shimi Eagleman was able to find. But I think to understand why it's a good question really is the starting point should be when an ETDL, an estate trustee during litigation, is appointed. And the essential point is that the authority of the court to appoint an ETDL is expressed in the Estates Act. I'll just read the relevant line in a moment, but there's no analogous provision for the appointment of a trustee or a neutral trustee in litigation in which a trustee is a party to litigation and is subject to allegations and so on. So that's why it's a good question. The provision in the Estates Act for the appointment of the ETDL, Section 28, starts with pending an action touching the validity of the will of a deceased person, or for obtaining, recalling, or revoking any probate or grant of administration. A Superior Court judge has jurisdiction to grant administration, etc., to appoint a neutral ETDL, a state trustee during litigation. Generally, they'd be whether a trust company or a senior lawyer or accountant are brought in to be neutral in litigation in which an estate trustee is a party. So I think perhaps the starting point is just to understand what's the point and what's the benefit of having an ETDL in place. And I'd make 3 points on that. First, I think it's actually quite a powerful weapon in the hands of an estate litigator and a party in the arsenal, because it effectively takes control of estate assets out of the hands of an estate trustee who might otherwise be using them possibly for personal benefit, if that's one of the allegations, or at the very least as a way of funding litigation and takes it away and puts it into the hands of someone who's neutral. So that's can be an important factor to consider early on. The second point is really the test as to the removal of an estate trustee when litigation is in play. And I would submit that the test is actually lower than when you'd otherwise want to remove an executor in litigation for allegations of wrongdoing of one kind or another. When you Probably the most commonly cited case is McCall Estate of Justice Greer, which is relatively recently, 2013. And in that case, one of her later decisions, she cites the Schnur text, which says that the decision to refuse the appointment of an ETDL should be made only in the clearest of cases. So generally the presumption will be once an estate trustee steps into the fray and is in litigation, generally they'll be removed. That's the presumption. So tactically, when there's litigation against an estate trustee, generally that'll be one of the early things for a litigator to consider, for a party to consider is do we bring a motion to appoint a neutral ETDL? And often the answer will be yes, because it puts potential beneficiaries in a stronger position than they'd otherwise be, and it's not that hard to obtain. So it's an important consideration early on. And I'd also add that the authorities, in fact, the recent authorities even more so, are pretty clear that the relatively narrow language in Section 28 are merely examples of the cases where an ETDL would be appointed. In other words, the language talks about an action touching the validity of a will. So effectively, will challenge type cases. But the cases where they've been appointed, there's a recent very good decision, I think, of Justice Myers called Mayer versus Rubin, Mayer, M-A-Y-E-R, and makes two main points. One is that the introductory language in Section 28 is really just examples of cases where ETDLs can be appointed, and they can be appointed broadly where estates are in, or estate trustees are in litigation. And secondly, ultimately, the authority of the court is not merely legislative, but comes from the inherent jurisdiction of the court to supervise trustees. And so, to give you one other example of where that happened, there was a case called Geffen Estate in 2015, where Justice Newbold appointed an ETDL. In that case, the issue was not whether the will was valid or not, but whether the wills were valid, but rather whether the husband and wife, before they died, had entered into a mutual will agreement promising each other that they would not change their wills, and effectively that their three sons would inherit after they died, meaning that the wife in that case couldn't give away her assets while she was alive. So the wills were valid, but the issue was whether they'd remain in force. So on that basis, Justice Newbold appointed Ronnie Rutman as a neutral ETDL, and ultimately on a motion to quash in the Court of Appeal, the Court of Appeal held that that was sufficiently within the language of Section 28, which should be given a broad and purposive interpretation. So generally, the ETDL, once it's in place, will be appointed and stay in place through trial and through the final disposition of litigation, including appeals. So I think it's a pretty useful instrument. So the question is, how are these principles applicable in the context of trust litigation involving a trustee? And the short answer is that even though there's no equivalent to Section 28 in the Trustee Act, nonetheless, the authority to appoint a similar type of neutral party is apparent in my submission. Both, I think really the simplest way is through the court's inherent jurisdiction to supervise all trustees. So I think that's the shortest path there. There's also room to use Section 5 of the Trustee Act. Section 5 is the power of the court to appoint new trustees, and it grants the court the authority to make an order for the appointment of a new trustee, either in substitution for or in addition to any existing trustee or trustees. So I think the power is contained in Section 5 as well, and there are cases where that's done. I also perhaps just briefly address generally where, because these cases are really subspecies of cases where courts remove whether they're estate trustees or trustees generally. And so I'll just briefly address the cases where that's done. The leading case is the House of Lords decision out of South Africa it's a Privy Council decision, 1884, called Letterstedt and Broers. And I'll just give you the punchline. First, what's interesting is that the court essentially says, look, where there's a dispute, where the beneficiaries are unhappy with what's going on, profoundly unhappy, and in a fight, they said there's very little case law on it, and the reason is that most lawyers will simply counsel the trustee to step aside, because if they've got no stake in the outcome, what's in it for them? Why don't they just move on? But having said that, the court essentially says that the main guide has to be the welfare of the beneficiaries. And so just as a way of a few examples for cases where, whether in a trust context or a state trust context, the kinds of cases where obviously the trustee is personally benefiting from a trust, which sometimes in some cases has included pre-taking compensation, that's resulted in, without the beneficiary's permission, that's resulted in the trustee being tossed. Conflicts of interest of all kinds, often they're tossed in those cases, although where there's an exculpatory clause permitting a conflict, they've been kept in. That happened in the Ballard Estate case with the purchase of the Toronto Maple Leafs by Steve Stavro in 1994. An estate trustee or trustee not understanding their duties, hostility with the beneficiaries, or serious disputes with them, or more fundamentally, acting in a way that materially damages the assets of a trust. Although there's an exemption in Section 35 of the Trustee Act where the trustee has acted reasonably and honestly, even in breach of the trust, that they can be kept in. So those are just a few cases to consider, and thank you very much.
Thanks very much, Aaron, for enlightening us on an area of law that we really, like you said, there's not a lot of authority on it, and so it was a very helpful discussion. Our last speaker will be Deb Stephens, who's going to talk to us about lawyers and accountants' negligence and how to avoid it, and if you find yourself in a claim, how to deal with it.
Well, thank you. And again, thank you to Charles and his firm for putting this on. There's always very interesting scenarios, and I would say this one today is a doozy. It creates a great deal of lively discussion and gives lots for us to talk about. As Chuck said, I'm going to talk about professional negligence. I am not an accountant. I really know nothing about accounting principles, so I will be weak on that issue, but I've tried. I love the names of the lawyers, novice, and amateur, and I will use those as we go through. I'm going to do an overview because later on you'll hear someone speak specifically on the issue of lawyers' negligence. I think Ellen is doing that, so I'm going to give an overview. And I must make a confession. I am not allowed to sue lawyers. I do work for our insurance company, and so I might be just a shade biased, but I have tried to provide a balanced approach. Bottom line, what is negligence? Negligence generally is a failure to take proper care in doing something. However, in the legal context, negligence is a failure to take reasonable care resulting in injury or damages. And that second part is very important because perhaps on the way over here, I might have gone over the speed limit. I am technically negligent. I have not met the standard, the speed limit posted, for that particular street. But thankfully, I didn't cause any damage. So while I could have been negligent, I have not created a damage. So those two parts need to go together to find and pursue really a negligence claim. And so as you can see, it revolves around a standard of care. As I said, the speed limit is the standard of care that our city has created for various streets. So the question here is, in order to establish negligence, has the lawyer or the accountant fallen below the requisite standard of care. Query then, what is that standard? We are entitled as self-governing bodies, accountants and lawyers, to make our own, to govern ourselves, and therefore there is rules of professional conduct that we must abide by in order to retain our ability to practice. And those rules for lawyers are set out in our rules of professional conduct, and they are in place to uphold the standards and reputation of our respective professions. And one of those rules, 312, says, a lawyer shall provide legal services to the standard of a competent lawyer, which involves not only legal but ethical principles. So when you hear issues about undue influence and conflict of interest, those are also ethical issues that we as lawyers and accountants must adopt, in addition to understanding and having the skill to provide the advice that we're presumably giving. It is not a standard of perfection. It is a standard that needs to be met in accordance with the rules and what would be a reasonably competent lawyer. And a lawyer can be incompetent if there are deficiencies in the lawyer's attention to giving the interest of the client full value. So what defines a competent lawyer? Well, it's defined in our rules of professional conduct. A competent lawyer is one who investigates facts, identifies issues, ascertains client objectives, considers possible options, and advises the client on appropriate courses of action. Did novice do that? That's a good question. I think many of us sitting here with the fact scenario in front of us might not believe that that was the level of competency that one would expect to see. There are other obligations that novice would have had. She has to be honest. She has to be, why do I call her a she? I don't know. She has to deal with the client with candor, and she must be aware of not becoming a tool or a dupe for a client. And the lawyer must be aware of and avoid conflicts of interest, because the lawyer has a duty of loyalty, confidence, candor, and commitment, and cannot really act for more than one client at the same time within the context of one issue where there's a conflict between their interests or where you haven't identified the joint retainer and taken steps to ensure that each individual is and has the same interests. So in that context, that big overview, and I said it was going to be, let's look at, oh my goodness, let's look at the facts here. Who in heaven's name is novice's client? I have no idea. Is it the parents? Is it Brad? If Brad is the only client, then there are repercussions. If it's the parents, then novice should have never acted, because it is clear from the meeting and the words that are expressed in the fact situation that there's words like, they prevailed. They ultimately prevailed upon Brad. Well, as Nimali said, that immediately speaks to the question of undue influence. If we're not alive, someone needs to look after your sister. Okay, but you are still alive, so let's just deal with something totally different. Where are the options being presented? Why can't you just have an investment advisor manage the money, and you can give money to your sister and create a Henson trust for when you're dead, if Brad dies prematurely? There's so many other options. Why don't you just loan money to the parents or gift money to the parents so that they can look after Giselle? Isn't it their responsibility to look after Giselle? You know, there's no alternatives that seem to have been suggested by novice, and there's just so many reasons why Brad's interests do not necessarily align with his parents' interests. His parent, or Jeff, the dad, is a stockbroker. Well, is there commissions being made if he manages a trust and continues to trade as a stock individual? It seems to me that even without addressing the issues of undue influence, conflict of interest, it clearly is a situation where Brad needed to be identified only as the client. If that was the case, he is the settlor, he's the one with the money, and the parents need to be thrown out of that room, and someone needs to sit down and figure out what Brad wants. If Brad doesn't really know what he wants, which again seems to come from the fact situation, well, maybe no trust should be created at all. So those are just some of the highlights, because the parents give the instructions, and Brad, we hear, is unsophisticated, vulnerable, all of those things which give rise to undue influence and a conflict of interest. I just add as one final note, we hear that Brad signed the document without even reading it, and just where he was told to. Well, I don't know, but the last time I checked, I wouldn't let a client do that. I don't care what happens. That's abdicating total responsibility for making sure that a client understands the information and the documents they're signing. So all of those things would argue in favor of the fact that novice maybe didn't meet the standard set out in the rules of professional conduct. I'm going to jump over to the accounting profession. They also have a code of conduct, and they have the same kind of duties to act diligently, carefully, etc. But they also have an interesting provision within their rules of conduct which says that the court can find that they owe a fiduciary duty to their client. And some of the factors that the court looks at are really interesting. They talk about the sophistication of the client, the vulnerability of the client, whether there's discretionary authority given to someone else. All of these issues that you see in the fact situation that we have before us should give rise to the accountants to see this individual at 18 who knows nothing about tax, knows nothing about trusts, and really take them aside and explain alternatives to them. You'll hear this afternoon later this morning, that there are issues with respect to the taxation of the trust. And quite frankly, my husband's a tax lawyer, thank God. I understand that Section 75(2) of the Income Tax Act is something where a lot of accountants make mistakes, and maybe they just weren't skilled enough to deal with this. So I'm going to take a total switch now. So I'm going to talk about the damage issue. Thanks. Are the lawyers really responsible? Are the accountants really responsible for the loss here? Isn't it partly the dad? I mean, the dad went out, he claimed compensation. We don't seem to see that there's any right to claim to take compensation in the trust document. He undertakes investment strategies, which obviously weren't good. Don't know when the trust document provides for a restriction on those investment strategies. Brad, sorry, but you're 37 years old, depending upon your time frame. You've been a lawyer for 14 or 15 years. What's your problem? You know, you're an estates lawyer. Haven't you asked somebody to account? Haven't you looked at your trust document? You're going back and forth to Boston. Shouldn't you have been getting some decent tax advice by now? You know, at what point is the individual going to be responsible for the limitation? This trust has been going on for a long time. He had to consent to some of the transfers to his sister. He consented to the transfer of the house to her. Brad, take some responsibility. You know, if I'm kicking the other side on behalf of the lawyer and the accountant, I'm going to raise these types of issues. You know, they have to. It's not always just lawyers, and it goes back to the damage issue. Yes, the lawyer could have been negligent. Yes, the accountant could have been negligent. But are they really responsible for all the damages? Or you can also say, did they create a trust situation, a trust document that permitted these things to occur? So, as I said at the very beginning, there are so many facts, so many things within this scenario that you could probably talk about it for an hour, but I'm going to stop. Thank you.
Thanks very much, Deb. So I think we have about 5 or 6 minutes for questions. I haven't received any questions from the floor, so I have a few questions that we talked about. This is one actually that Nimali and I talked about, and because it's not being touched upon later today, and that is that Giselle, the sister, was on ODSP. And when you have a beneficiary in ODSP, what considerations do you have to take into account before you consider moving to bust the trust?
Yeah, thanks, Chuck. I thought, we should maybe just touch on this a bit because I don't know how much it's going to be discussed during the course of today. And, it is something to consider. In general, going back to my talk about the three certainties and trying to bust the trust, I did say that was the starting point for any challenges, but actually the real starting point is what are you trying to achieve, and what could the possible result be if you actually bust the trust? Because busting the trust may not actually be what you want to do. So for example, if busting the trust results in the interested individuals not having any interest in the property as a result. So if they're not the intestate beneficiaries, for example. Or in the case of this question, if busting the trust, if Giselle somehow has some claim here, some interest, if Brad really did want to benefit her, if she really has some interest here, is busting the trust the best thing to try to do from her perspective? Did she ever get ILA at the time this was established? Did the lawyer turn their mind to the ODSP issues? So was the trust drafted properly to be a proper inter vivos Henson trust, so that payments made out to Giselle would be limited to the ODSP rules and the types of payments that could be made, so as not to disentitle her from her ODSP benefits? I doubt it. From our fact scenario, it doesn't seem like those issues were considered beyond the simple issue of, well, she's on ODSP, so let's make this a trust. Is it the right kind of trust? And then for the last 15 years, have the payments to her been in keeping with the ODSP rules, the ever-changing ODSP rules? So there's a bunch of questions to unpack there, and certainly Brad needed his own separate lawyer in this, but Giselle should also have had a lawyer speaking on her behalf.
Thanks very much, Nimali. I think we probably only have time for one more question, and I'm just going to throw it out there, not to anyone in particular. We can have a free-for-all. But could the trustee, in this case, rely on an exculpatory clause or Section 35 of the Trustee Act to shield the trustee from a claim for negligence or breach of fiduciary duty? So perhaps whoever takes this question first can just talk very briefly what I mean by an exculpatory clause and Section 35 of the Trustee Act.
Okay. Exculpatory clause, a clause within the trust agreement that says, if my trustee acts in good faith, I excuse him, her from any mistakes or errors, and they will have no liability. So they're given a free rein, maybe. No, it's not true. An exculpatory clause is very common in family trust agreements. It's to avoid things like if you happen to purchase Nortel and Nortel dumps, are you going to be given a pass? And the answer usually would be yes. But there is case law that says, and it's the Court of Appeal Penman decision, which says, okay, yes, the exculpatory clauses are intended by the settlor, whoever put the trust together, to allow the trustee to manage and act in good faith and not be responsible for everything that goes wrong. But Penman was a situation where there were three trustees. One of the trustees simply let the other two do whatever they wanted, signed whatever came down the tubes, and needless to say, the other two took all the money. So the Court of Appeal said, no, you can't abdicate your responsibilities. You can't delegate it to the other trustees. You are still responsible. You have a duty to act in good faith, and you actually have a duty to act. You just can't turn around and abdicate your responsibilities and think that the exculpatory clause is going to give you the ability to exonerate yourself from liability. So they're there and they are useful, and for the most part, if you have actually undertaken the duties of a trustee, acted in good faith, and something happens, you will probably be okay, but you have to really ensure that you are acting as an estate trustee and turning your mind to the issues that you have to address.
Thanks very much, Deb. And I think we're out of time, so I want to thank members of the panel for great presentations, and thank you all for your attention.